You may start taping. I am also recording and the attendees are starting to file in. Deborah, I think you can start now.
Okay. Hello, and welcome to our presentation of Vote with the League, where we will discuss the League's position on the state and local ballot measures on your ballot. My name is Deborah Scheffler, and I'm president of the League of Women Voters of Oakland. Thank you all for coming, and we hope you find the next hour and a half helpful and interesting. You can find our recommendations on all of the measures at lwvo.org. Just click on Vote with the League. Please also go to votersedge.org to see what's on your ballot. Just fill in your address and zip code, and up will pop all the information about the candidates and ballot measures on your ballot in English and in Spanish. You should also check out opendisclosure.io to see which groups and individuals are supporting or opposing the various measures we'll be discussing. This is something we will be going over with you today. Now, the League has two hats, education and advocacy. You may have seen our Easy Voter Guides, attended a pro-con presentation on ballot measures, attended a League-sponsored candidate forum, or used VoterEdge to help you work through your ballot. All of those come under the heading of voter education. We don't take a position. We just present fair and unbiased facts for the public to consider. But this morning's session is different because we're going to go over our positions on the measures and tell you what we think about them. We don't ever support or oppose candidates for office, but we do take positions on ballot measures. We are able to do that because we carefully study and analyze every measure. The League of Women Voters of California does this for the state propositions, 12 this time. Each local league, including the League of Women Voters of Oakland, does this for local, county, and regional measures, 6 this year. Over many years, the League has studied and developed general positions on most topics that arise through ballot measures. So when studying an individual ballot measure, one of the things we do is look at how well it aligns with positions we have taken. For example, we have positions on taxation. So we look at taxation measures through the lens of our positions. As you will hear, we take one of 4 positions on each proposition or ballot measure. The first one is support. This means we support the measure and that we urge you to vote for it. The second one is oppose. This means we oppose the measure and we urge you to vote against it. We also take a neutral position at times. Now, this means that we have a position on the general subject of the measure and we could support or oppose it, but the balance of considerations leads us to take a neutral position, neither supporting nor opposing the measure. And finally, on some measures, we take no position. And this means we haven't studied the issue raised, and therefore we take no position on it. Now let me introduce our panelists, which includes myself and 3 of my colleagues. Helen Hutchinson, who is the past president of the League of Women Voters of California and a longtime member of the Oakland League. Special thanks to Helen for preparing the slides that we will be using today. Gail Wallace, chair of our very active action committee, which is responsible for analyzing local ballot measures, and Mary Bergen, our legislative analyst. Mary has done much of the heavy lifting of analyzing local measures over the years. This year, she helped train teams of analysts, one for each measure, to study and make recommendations. Special thanks to Pat Rayburn for helping with Zoom tips, to Angie Crone for providing our tech support, to Kathleen Cha, Eleni Hub, Vita Flores, and Carolyn Gray for communications support. The agenda calls for us to go through the measures, first the state and then the local. We will have time for Q&A after we finish the state propositions, and then again after we finish the local ones. Please type your questions into the QA tab on your screen, indicating the measure number or letter. Gail will start us off with Prop 14, then Helen will discuss Prop 15, I'll discuss Prop 16, and Mary will take up Prop 17, and then we'll continue in that order through the measures. Gail?
Good morning, everyone. Well, let's start with Prop 14, which, if it is approved by the voters, would authorize a bond measure, and the funds from the bonds would be used to continue stem cell research. Let's recall that a bond measure proposes that the state government borrow money and pay it back with interest over time in order to finance a project that cannot be financed through regular revenue streams. In this case, proponents of Proposition 14 are proposing $5.5 billion in bonds, which would be paid back together with $2.3 billion in interest over 30 years for a total cost of $7.8 billion. Repayment would break out by year to the amount of $260 million. And the bonds would be sold gradually over a period of 11 years to spread out the repayment. And the first 5 years of interest payments on the bonds would be paid from bond proceeds rather than by the state, so as to mitigate the impact and give the state a bit of time to recover from the current financial crises. The purpose of these bond funds is to fund the work of the California Institute of Regenerative Medicine, which does research, both basic and applied, into the uses of stem cells to treat and cure diseases. Let's get a little background here. In the early 2000s, stem cell research began to seem very promising. If you recall, stem cells are cells with the potential to develop into a variety of specialized tissues. And certain stem cells are derived from human embryos. That was the point of contention back in the early 2000s, as some people opposed on moral grounds any use of stem cells derived from human embryos. And in 2001, as a result of those controversies, the federal government halted its funding for stem cell research. In 2004, Californians responded by approving Proposition 71. Proposition 71 authorized under the state constitution stem cell research of all sorts. The bond measure at that time was $3 billion. And it was used to establish the California Institute for Regenerative Medicine, which then funded research into treatment and clinical trials, as well as basic research, into the refurbishment and development of facilities, and into fellowships for medical students doing research in this area. So the issue's coming back to you now because only $132 million of the original $3 billion remains. There are a few changes to the Institute that are proposed in this additional bond measure. They propose to expand the size of the oversight committee. They will create an advisory board, which will focus on patient access to any treatments that are developed and to clinical trials that are ongoing. They will limit full-time staff. They provide that any resources that are generated because of inventions will go to pay for patients' treatment in the clinical trials. And there's more of a provision for the grants to be more widely distributed through the California State University system, the community colleges, and the UC system. Finally, what the proponents of this measure propose is 1.2 billion of the funds be specifically dedicated for research into Alzheimer's, Parkinson's, and other diseases of the brain and the nervous system. That represents about 27% of the 5.5 billion that they're asking for. So the proponents of this measure, now you're going to see a slide about who is funding advocacy here. And the proponents of this measure say it's absolutely imperative to continue this research to save lives and prevent suffering on a range of diseases. They also say that the California Institute and its work contributes significantly to the California economy with its grants to researchers, institutions, and its support of clinical trials. Opponents contend that there are built-in conflicts of interest and a lack of accountability to public officials, despite the fact that the Institute is funded entirely with public funds. Also, a key factor that was present when Prop 71 passed was that the federal government was not funding this type of research. The federal government is once again funding this kind of research, and opponents of the measure say that that means that the federal government and private sources should now be the funders. Opponents also say that California in these times needs to be investing in healthcare, housing, jobs, education, and other pressing needs. And finally, opponents say that the initial bond money was intended to provide one-time startup funds, and the idea was that the Institute would find its way from there. Now to our position in the League. This is one of those instances where we have positions in the League that could point in two directions, and we've decided to remain neutral. We have positions that support medical services and medical research in service of quality medical care for all. However, we also have positions on state finances. One position says that general obligation bonds like these are generally used for three purposes: capital projects, purchase of facilities for public use, or the repair and retrofitting of public facilities and structures. So this use is outside the realm of what we normally would approve for general obligation bonds. Also, we have positions that limit the flexibility of the legislature. This proposition provides that it requires a supermajority of 70% to change anything in this proposition. That would be 70% of the legislature. And finally, the proposition provides that profits from intellectual property agreements could only be spent on their own research treatments within the Institute. And we have positions that would encourage more flexibility for the state to use the funds on matters that might be more urgent. So our position on this one is neutral. And I think I'm now passing the baton to Helen Hutchison.
Yep. Thanks, Gail. I'm going to talk about Prop 15, the Schools and Communities First measure. Prop 15 is deals with property taxes. In 1978, in California passed Prop 13, which set the statewide property tax at 1% and fixed the assessment for each property until it was sold. Property tax is a major source of funding for our schools, our counties, cities, and special districts. So schools and local government, I like to say. Prop 15 would change the rules for commercial property and only for commercial property. It does not apply to any property where people live, no matter what the zoning is. And so when we say commercial property, it is by use rather than necessarily by zoning. Commercial property would be reassessed every 3 years. In addition, the personal property tax, which is a tax that businesses pay on their equipment and fixtures, for all businesses would be exempt for the first $500,000 of their equipment and fixtures. There is an exception to the reassessment that small businesses where their property value is less than $3 million would only be reassessed if it was sold. The increased revenue that this would generate would go to our schools and to our local governments. About 40% of it statewide would go to the schools, and that money will be distributed statewide using the local control funding formula, LCFF, which is an equity formula that makes sure that schools and districts that have more high needs students get more money. The balance, that 60%, would go to local governments. And the people in favor of this measure, and I'll move over here so we can see, say that local schools and communities have been starved for the past 40 years, and this is going to help rebuild our local communities and make them strong. They emphasize that it keeps the Prop 13 protection for homeowners, renters, farms, and small businesses. The people against it say that this is the biggest property tax increase in California's history, and they also then have a lot of falsehoods and scare factors that they are using to cause confusion among voters. The League's position is that we are in support of this. We are one of the proponents of this measure. And we feel like businesses should help pay for the services that we all use and need. Schools that provide California's future workforce, infrastructure that actually works, and healthy and strong communities. I think that I'm ready to pass it off for the next person. I'm not sure who that is, but I'll move to the next slide.
Speakers, we have a question for clarification on positions that the League of Women Voters of Oakland might take that might be different from the League of Women Voters California.
So let me just say that on state measures, the state league is responsible for acting. The league, so the league's policy is we speak with one voice. So if the issue is a national issue, the National League takes that position, and state and local leagues can choose to remain silent, but they may not act in opposition to what the National League says. And likewise, the state league takes the position for the league in California, and local leagues may then choose to remain silent on the issue, but they may not act in opposition to what the state league says. So the position is taken by the state league on these matters. Okay. Moving on.
I have the next one, Prop 16. The League's position is to support equal access to education, employment, and housing. Therefore, the League is a proponent of Prop 16. Before 1996, California and local entities had policies and programs intended to increase opportunities and representation for people who faced inequalities as a result of their race, sex, color, ethnicity, or national origin. These were often called affirmative action programs. For example, some California public universities considered race and ethnicity as factors when making admissions decisions and offered programs to support the academic achievement of those students. In 1996, Prop 209 banned affirmative action programs in public education, employment, and public contracting. Without equal opportunity programs, schools and public institutions cannot take race, ethnicity, national origin, gender, or other factors into consideration when admitting students to colleges, hiring employees for public jobs, and selecting contractors for public projects. This prevents decision makers from getting a full picture of an applicant and their qualifications, which often puts women and people of color at a disadvantage. In the 24 years since its passage, Prop 209 has had far-reaching negative consequences. Since 1996, there has been a 12% drop in enrollment of students from underrepresented groups across the University of California system. This drop has caused underrepresented Californians to experience declines in college graduation rates, graduate school admissions, and completion rates, and average wages. Similarly, public sector jobs have become less attainable for certain groups since the passage of 209. In particular, men and women of color remain underrepresented, especially when it comes to top managerial positions. During the same period, women and minority-owned businesses lost billions of dollars annually in public contracts they might otherwise have won. Opponents of Prop 16 say it would be a step backward, introducing a new form of discrimination. But Prop 16 won't allow discrimination in any form. California has some of the strongest anti-discrimination laws in the nation, none of which would be altered by Prop 16. Prop 16 won't allow quotas for college admissions. Quotas are and will remain illegal if Prop 16 passes. We believe that everyone, Black, Latino, Asian American, white, Native American, man, woman, or non-binary, deserves a fair shot at success. We support Prop 16 because it is a chance for our public institutions to reinvest in diverse communities. Our government has the responsibility to provide equality of opportunity in education, employment, and other areas. Prop 16 will make quality education and robust careers accessible and attainable for more Californians. And finally, since the passage of 209, California has not become a more equitable state. In many ways, we have regressed. The nationwide Black Lives Matter demonstrations show that discrimination and inequity are still deeply ingrained in our institutions. The pandemic and its economic repercussions disproportionately impact people of color and other historically marginalized communities. With Prop 16, we will restore an important tool to ensure an equitable recovery, confront racism and unfairness in our state, and empower the next generation of students, public servants, and entrepreneurs. And here are the parties who support Prop 16 and those who are against it. As you can see, the League of Women Voters of California, this is a state measure, so the California League supports the rollback of Prop 209. Thank you, and I will pass this on to Mary.
Good morning. I'm not used to being unmuted, to being muted, so I have to unmute. I'm going to deal with Proposition 17, which restores voting rights to those on parole. Now, the League is really dedicated to expanding the franchise to everyone. And, but voting rights for those who've been convicted of a crime really vary from state to state. Now, and in California, we currently have people who can register. or people who have been convicted of a crime and or who will be able to vote. These include anyone that is in county jail because they're serving a misdemeanor sentence. And a misdemeanor never affects your right to vote, incidentally, or because jail time is a condition of probation, whether it be for a misdemeanor or a felony, or if they're awaiting trial. They can vote if they're on probation, and the league was really quite instrumental in bringing people that right if they're on probation. Also, if they're on mandatory supervision, post-release community supervision, or federal supervised release. However, anyone who is serving a state or federal prison sentence or on parole cannot vote in California. Proposition 17 would give people who are give those on parole the right to vote. As you may know, those who are on parole have to meet conditions of parole, and this would be true for everyone. And they have different levels of supervision as well. Now, whether you support or oppose it, and the league supports Proposition 17, seems to depend on how you view parole. For the league, parole should be an opportunity for individuals to come back into the community, to establish themselves. And it's really a matter of justice. Those who are opposed, see it as a continuation of a sentence that was instituted for punishment. There are currently 50,000 people who are on parole and who are denied the right to vote. To help bring those folks into their communities, reintegrate into the communities, and I would add that the Oakland League actually has a project to help folks who have been incarcerated, to help them reintegrate into their communities and become active citizens. So vote yes on Proposition 17. Let's be fair. And now we go back to Helen. Oh no, excuse me, to Gail, who's going to talk about Proposition 18.
Thank you, Mary. Okay, Proposition 18 would amend the California Constitution in a very specific way to allow 17-year-olds to vote in primary elections if they will turn 18 by the following general election and are otherwise eligible to vote. So the general situation here is that in even-numbered years, we have two elections. One, we have the primary election in the first trimester, generally March, and then we have the general election in the fall, just like we did this year. And what happens in the primary election is that those of us who vote, choose the candidates who will be on the ballot in the general election. So at the moment, if you are 17 when the primary election is held, you're not allowed to vote. But if you turn 18 by the general election, then you can vote, but you will have had no say in those people for whom you are voting. So this proposal suggests that let someone who is going to turn 18 by November, but is not yet 18, vote in the primary election. And we would take our place with 18 other states, as well as the District of Columbia, if we pass this proposition. And the fiscal impact is pretty small. For counties, it would be several hundreds of thousands to $1 million every 2 years to process the voting materials. And for the state, there would be a one-time cost of hundreds of thousands of dollars to update voter registration systems. Now, the proponents of this measure say that this would allow young voters to participate in a full election cycle and have a say in the nominees. It encourages voting in the general election for this slice of the population who would turn 18 between the primary and general elections. The proponents also say that young people have shown political commitment and capability on the issues of gun violence, the environment, and racial justice, so that they have proved themselves well capable of making the kind of decisions we ask of our voters. Proponents also say this would encourage better representation of the electorate, because currently the youth vote is disproportionately low. They finally say that when people start voting young, when they haven't left school yet, then they are interested in issues, they're studying the issues, and there's a chance here to encourage a lifelong habit by allowing them to start at 17. Opponents say 17-year-olds might be subject to undue influence from their parents or their educators, as they are still in school and most often living at home. And they also say that persons age 17 have little to no experience with budgets and the kinds of issues that will be addressed in the propositions. The League recommendation on this issue is to vote yes, because we have positions that encourage an active and informed electorate, that encourage all citizens to vote. And we feel there is a fundamental fairness in allowing 17-year-olds to have a say in who they will vote for in November. And we are interested in increasing the representation of youth in the electorate. So the League position is yes on 18. Thank you.
So it's back to me. This is Helen, and I'm going to talk about Prop 19, which is another measure that deals with property taxes, but it's a different one than we talked about before. Currently, people who are 55 years or older can transfer the lower property tax rate, their lower property tax value, to a new home if they're doing that within some counties. And they can only do that once in a lifetime. This ability to transfer lower property taxes applies also to those with disabilities or who lose a home in a natural disaster. The other thing you need to know about the current situation is that if you inherit a home, you can keep that lower property tax rate no matter, and go on with that, no matter what use you make of that home. Prop 19 would do two things. It would expand the ability to transfer that lower property tax and would apply anywhere in the state. It could also happen up to 3 different times. So you could keep a low rate and transfer it up to 3 times. It includes moving to a more expensive home. So you can, if you're 55 or older, you can upgrade your home and keep a lower tax rate. The other thing that it does is it says that those taxes on inherited homes would have to go up unless the house is a primary residence for the person who inherits the house. And because of that, there'd be some increased revenue. So because taxes would go up on inherited homes that were not primary residences, they were either rented or they're a secondary residence, that increased revenue would go into a special fund to support fire suppression. So the people who are in support of this say that you shouldn't have to pay higher taxes if you lose your home in a disaster, that it protects older homeowners, and it closes a tax loophole on inherited property. People who are against it say we rejected this same measure or a very similar measure in 2018, and that the reassessment would force families to sell their homes. The League of Women Voters says no on this measure, and we like the fact that it takes that it does the reassessment on the higher for people who inherit a home and it's not their primary residence. But in reality, we're offering a tax break to people who don't need it. It's providing a tax break to seniors, and that does nothing to provide low-income seniors or families struggling to find housing. It doesn't do anything to help them. As I said, it's good to close that loophole on inherited homes, but we also think that putting that money in a special fund makes it more difficult for the legislature to fund the state's response to any other kind of natural disaster or public health crisis, because it is just for firefighting. So I'm going to move it back to Deborah.
Okay. The next one is Prop 20, Criminal Justice Reform. In the past decade, California has passed 3 measures. There was AB 109 in 2011, Proposition 47 in 2014, and Proposition 57 in 2016. These measures were intended to reduce the state prison population. Specifically, AB 109 shifted people convicted of a variety of nonviolent felonies from state to local county jails, a change that was called realignment. Prop 47 redefines certain nonviolent, non-serious felonies as misdemeanors unless the defendant had previous convictions for certain violent crimes, and it allowed resentencing for people convicted of the redefined offenses. And Prop 57 increased opportunities for parole for people convicted of nonviolent felonies who had completed the sentence for their primary offense. The League believes alternatives to imprisonment should be explored and utilized and opposes mandatory minimum sentences for drug offenses. We oppose threats to basic constitutional rights, and we support a criminal justice system that is just, effective, equitable, transparent, and that fosters public trust. Prop 20 serves none of these goals. This measure attempts to weaken realignment and the 2 voter-enacted measures that the League has supported. Specifically, this measure will make it more difficult for incarcerated people to get Prop 57 parole relief. It also would reverse some of the Prop 47 reforms in which crimes that can be charged as either a misdemeanor or a felony were lowered to misdemeanor charges. Proponents believe that such a reversal will keep the community safer and will help stop car break-ins, shoplifting, and other theft that has been on the rise. But reducing nonviolent crimes to misdemeanor charges does not increase violent crime. Prop 20 would result in longer incarceration for many, and proponents claim it would not increase the prison population, but that it would just ensure that people convicted of these crimes serve their few full sentences. But longer sentences do not lower recidivism rates. This measure also expands DNA collection that is allowed by Prop 69, which the League opposed in 2004. Prop 20 would erode individual rights because even if a person is not guilty, the onus for removing the person's DNA information from records is placed on the individual, not on the state. Furthermore, some of the DNA expansion in the measure extends to Prop 47 misdemeanors such as shoplifting, check forgery under $950, and petty theft. While these types of offenses became misdemeanors under Prop 47, Prop 20 would effectively increase the penalties by encroaching on the individual liberties of suspects through DNA collection by law enforcement. So vote no on Prop 20's proposed rollback of criminal justice reforms that California has thoughtfully developed and implemented to create a more equitable public safety process and reduce our prison populations. And here again are the parties opposing and supporting this measure. And as you can see, the League of Women Voters of California is against this measure. Thank you. And I will pass it on to Mary.
Okay. Okay, we're going to be dealing today or here with Proposition 21, which is sort of a familiar topic. There's been legislation on it. In fact, some new legislation this year. There was previously, we saw Proposition 10, which would have repealed Costa-Hawkins, the current state law governing rent control in California. And that law limits the extent to which local rent control laws can operate. Rent control cannot apply to any single family homes. It can never apply to newly built housing that was completed since early 1995. In other words, 25 years ago to right now. And they can't say how much rent can be charged to a new renter moving in. So they can't put limits on that. Now that's one of the things actually that new legislation has just done, and that is put a limit on. So Prop 21 and just 2 years ago, of course, we had Proposition 10, which failed and which would have completely repealed Costa-Hawkins and all of the limitations that it put on. But it didn't do it. It failed. So the proponents of Proposition 21 have taken a different tack. So they are amending Costa-Hawkins rather than repealing it. And rent control would be able to, those who want, cities that wanted to enact rent control, they would be able to apply it to all property more than 15 years old. So instead of a date certain, they have a time. So that, so the date they to go back to would of course keep going up. And it applies to people that have 2 or more properties to rent. Rent control could also, and it does put limits on rental rates after a unit is vacated. And as I said, current law already does that. Rent control is a very contentious issue, shall we say. And it's been very difficult to find the right balance. So the league is neutral on this. And the supporters say that even small increases force renters into homelessness. And we certainly, as we all know, have seen a rise in homelessness. And that because people are paying such a high percentage of their incomes for rent that for many people, particularly seniors and veterans, people on incomes that don't move, they're left with very little money for anything else, food, medical care. And they point out that Proposition 21, as it must actually, guarantees landlords a reasonable profit. The opponents claim that rent control results in less available and less affordable housing, and it would stop new housing from being built, therefore costing jobs and hurt our economic recovery, such as it is. So we're neutral because there's conflicting research regarding rather short-term versus long-term effects on the rental market and on renters. So you're on your own, guys, for this one. And so now we go back to Gail.
Okay. All right. Thank you all for being here with us this morning. We're entering the last round here. State measures. We know there's a lot of them, which is why we're really glad to have a chance to spend this Saturday morning talking about them with you. So we're on to Prop 22. This would change the classification of employee rules for app-based transportation and delivery drivers. Companies like Uber, Lyft, and DoorDash would like to carve out an exemption for themselves and those that they hire. They do not want to be subject to the current prevailing law in California, which would otherwise classify their drivers and deliverers as employees and require the companies to provide state mandated protections. So the background here is that people who are hired have traditionally been classified as either independent contractors or employees. And with the development of a gig economy, questions have arisen and people have argued for a third status or perhaps multiple statuses. All this is playing out against a legal and legislative background. A recent appellate court case, the Dynamics case, set out a three-part test to distinguish independent contractors from employees. And in 2019, last year, the state legislature codified the court's standard in Assembly Bill 5. And while that bill, Assembly Bill 5, and subsequent amendments have identified about 50 exemptions to the bill, Uber, Lyft, and the other delivery companies were not among those exempted from the effects of AB 5, which would require them to classify those they hire as employees and consequently to provide them with the usual employee protections. Uber and Lyft decided they were not going to proceed as the law directed and were sued by the Attorney General of the state of California, as well as local officials in San Francisco, LA, and San Diego. At the moment, the appellate court case is on hold, and the court has given the companies more time to develop a plan to transition. So the companies pivoted to bring this measure to you, which would allow you to make the decision. And what they want to do is to be exempted from AB 5 and to continue to consider their workers as not as employees. However, so they would not be paying minimum wage or overtime or paying for sick leave or family leave or unemployment compensation or workers' compensation insurance. All those things would be off the table if they're allowed to avoid AB5. What they're proposing instead is that they will give some worker protections. They will put a cap on the hours that drivers can work in any given day. They would pay 120% of the minimum wage, but only for the hours that their drivers are actually working, not while they're waiting between rides. And they would add 30 cents per mile to the compensation. Rather than providing health care, they would get an insurance policy for up to $1 million that would cover their drivers if they are injured while they are driving. And they would also compensate them for lost wages. They would additionally provide some trainings in safety and on sexual harassment matters, and they would require criminal background checks. Nonetheless, the package that is being proposed for the drivers of app-based transport and delivery companies would not be as significant as regular employee protections and the package of compensations that an employee would normally get. The law has been written in an interesting way, requiring a supermajority to change it. So there's an attempt by these companies to lock this in by requiring a 7/8 vote in both bodies of the legislature, plus the governor's signature, to make any change in this law if it should pass. And the only changes that could be made, even in those circumstances, would be ones that enhanced the legislation. The effect of that is to say, basically, if the voters adopt this, that it could only be changed by another referendum, that is, by coming back to you, the voters, for changes. The proponents here say that if you don't pass this, then hundreds of thousands of jobs are going to be lost in California. And there could be a curtailment of services in areas of low demand and also during non-peak hours, because the company's expenses would go up and therefore there would be fewer people that they could pay and diminished services that they would offer. And proponents also argue that Proposition 22 is necessary to recognize and open the door to a new classification of worker, the gig worker, who will have fewer protections than employees, but more than traditional independent contractors, and will have the advantage of flexibility. Finally, the companies say that they provide a service, an important service to those who do not own cars and who are not well served by public transit. Opponents of Proposition 22 say that they're providing fewer comprehensive benefits and worker protections to ride hailing and delivery drivers than they would receive under AB 5. They also say that this would exempt the companies from paying millions towards public safety net programs like unemployment insurance and paid sick leave. And that passing a measure with this degree of impregnability is a risky practice because it makes it very difficult to course correct later on. And finally, it says the opponents say that preempting the legislature, saying we don't want to abide by AB 5, and also working around the court sets a dangerous precedent for trying to make policy for those who can afford to gather signatures for a referendum and spend a great deal of money in its favor. As you can see from the slide, this is a measure in which considerable sums have been expended, principally by Uber, Lyft, and DoorDash. So the league's position in this case, it's that interesting fourth category where the league has not studied these issues of the gig economy and where we stand on the balance of the worker protections and the flexibility and minimized protections. And so we take a stance of no position. So once again, you're on your own, except for the benefit of all this information. Helen.
Okay, thanks. So on to another complicated one, Prop 23, which is kidney dialysis, has to do with kidney dialysis clinics. And it's another repeat of a measure that we've seen similar ones before. Prop 23 would require that dialysis clinics have a doctor present during all treatment hours. They'd also be required to report dialysis-related infections every 3 months. And then clinics would need permission to close or reduce their services. So it is trying to provide more regulation for the dialysis clinics. And you'll see by the proponents of it are the main proponent is SCIU for in terms of money, and then dialysis nurses and patients are the other proponents. And they're saying that patients should have access to a doctor whenever a dialysis is being provided, and that we need protections for patients when clinics close. Those opposed to it say that it would make the physician shortage that we're seeing right now even worse, and that dialysis is already strictly regulated. And you'll see that the major groups against it are the owners and the managers of the clinics, and the medical association, also the nurses association. The league position is that we are neutral on this. We have positions on healthcare, but we're really uncertain. It's really unclear to us what the costs and benefits of this measure would be. So we end up being neutral because we can't determine what that would be. And I'm going to go back to Deborah for Prop 24.
Okay, Prop 24 is about consumer data privacy. So in 2018, California passed the California Consumer Privacy Act. The CCPA guarantees consumers certain rights and protections with respect to the collection and sale of their personal information. Consumers have the right to know about and access the personal data a business collects, and if it's sold or disclosed, they have the right to opt out of the sale of personal information to third parties and request the deletion of personal information collected from them. Either consumer or parent guardian permission is required to sell personal information of minors, and the CCPA also provides a right to equal service and price, whereby businesses may not discriminate or provide inferior service if the consumer exercises their privacy rights. However, businesses may offer financial incentives for the collection or sale of personal information. Now, Prop 24, the California Privacy Rights Act of 2020, the CPRA, proposes to revise the CCPA. It contains some beneficial elements, as proponents point out. For example, it would create the California Privacy Protection Agency to hold companies accountable and impose penalties for infractions. It would allow consumers to request that businesses not share sensitive information about health, genetic data, finances, race or ethnicity, religion, sexual orientation, private communications, or precise geolocation. And it would triple the fines for violations involving children's privacy. And there are some additional beneficial aspects of this proposition. But the League opposes Prop 24 because its beneficial elements are outweighed, in our view, by its privacy rollbacks and numerous shortcomings. So, for example, it would allow businesses to charge consumers more to provide worse service if they choose to exercise their privacy rights. It also allows businesses to require consumers to direct each individual website and app not to sell information, weakening the current legal requirement that companies respect a global opt-out for all services. Now, while global settings may not yet be available, they will be soon. These burdens place the onus on the average consumer to protect their own privacy. Working people don't have the time to do the paperwork, and they can't afford to pay companies to respect their wishes. Prop 24 will disproportionately harm vulnerable communities like the poor and the elderly because of these provisions. Instead of limiting the collection of a consumer's personal information to what is necessary to provide the service or good a consumer seeks, Prop 24 allows the business to collect consumer information according to the business's view of what data is needed to accomplish its commercial purposes. And Prop 24 weakens consumer protections for businesses collecting biometric information such as DNA or face prints. And please see Vote with the League at lwvo.org for a more complete list of the shortcomings of this proposition as we see them. Furthermore, we oppose it due to the complexity of a 52-page initiative with impacts and nuances that are difficult for voters to discern. Prop 24 will be difficult for most voters to understand. It is the role of the legislature to grapple with matters like this in an open and transparent manner through a process that offers the opportunity for hearings, debate, and public engagement. And finally, the initiative comes less than 1 year after the 2018 California Consumer Privacy Rights Act went into effect, before we have had an opportunity to see how the new law works, or that the legislature has had a chance to address any defects. California's businesses are now working to implement the 2018 CCPA legislation, so it is too soon to ask businesses to respond to a whole new set of regulations that still do not meet privacy standards required to protect consumer data from misuse. And for our final one on, I'm gonna pass on to Mary.
Okay. End money bail, Proposition 25. This is a proposition that the league supports. Basically, what it does is it eliminates cash bail for people who are arrested, who are awaiting trial, and replaces it with a system that would have to be created, a system of risk assessments that would categorize suspects as a low risk, medium risk, or high risk. An individual who is assessed as low risk would be freed with a date that he or she would have to come back and either get charged or have a trial. High risk individuals would be kept in jail. Medium risk, it would, that's particularly where this assessment tool would come in. And the courts could determine whether the person should stay in jail or be freed and told to come back. And in many cases, in some cases, many people with misdemeanor charges or misdemeanor arrests would be released. The supporters, including the league, say that the current law really favors rich defendants who can easily make bail, and poor defendants and defendants who are often, of course, defendants of color, have to stay in jail. whether or not they are, and this sort of runs against the idea of innocent until proven guilty, because you're already being punished by having to stay in jail. And bail can be quite high, because usually usually people go to a bail bondsman and say, and have to pay about 10%, which they don't get back, so that the bail bondsman can actually put up the bail, can actually pay the court the bail, and the bail bonds company will get the full amount back when the person shows up for trial. But people can be, so arrest can be a very, very expensive operation for you, even if you are eventually not charged, charges are dropped, or you are not, or you are found not guilty. Opponents say that the intentions are good of SB 10. SB 10 is the legislation that this is confirming, and its provisions, but that its provisions could eventually result in more people being put in jail than under the current situation. Primarily, the argument is primarily made that discrimination plays a role here, discrimination, particularly against minorities, and that it will end up costing hundreds of millions of dollars a year, overburdening the courts and creating a new bureaucracy through this assessment tool. The reason that the reason that the League supports it, again, is that fairness and an ability to keep, and bias towards keeping people in their communities, and in fact able to keep earning a living and running their lives. And if people who are little threat, and this is the main criterion in SB 10, who are little threat to the community, shouldn't be subject to losing their incomes, losing their families in many cases, simply because they don't have the money even to pay that 10%. Now, I think it's important to point out here that while SB 10 might not be the perfect law that we would write, it can be amended and made better by the legislature. If, however, the no vote prevails and SB 10 is totally thrown out, under court decisions that we've had, the legislature is not going to be able to come back in with another piece of legislation to throw out or to eliminate money bail. So this becomes really important, because basically, if this fails, it's hard to know when we will ever be able to reform this system reasonably. So, vote yes on 25. Thanks. And with that, it's question time.
Right. And this is Helen, and I'm just going to point out that as we get questions, and you please enter them into the Q&A, and Angie's going to ask them, I'm going to show this kind of busy slide. It shows the relative donations for ballot measures. The shades of blue there on the left are the proponents are yes, people urging a yes vote. Shades of red are on the right are no votes, no urging. And you can just see that definitely Prop 22 is the big spender of this this election cycle, although there's some others that are pretty high up there also. So Angie, you want to start asking questions, and we'll all chime in as we're needed.
Thank you. So we have a little more than a dozen questions, and we're going to start all the way up on Prop 14. So going back to the very beginning. So we have a question from Bobby where they're asking, the opponents say that money is going to some companies headquartered outside of California for research. Is all the research being conducted inside California, or is there any research being done using this fund's money outside of California?
I have read, thank you first of all for the question. And yes, I have read rebuttals to the idea that all of the money generated by the bond and the subsequent research is money brought into the California economy because some of the research funds have been granted to institutions or researchers outside the state. I cannot cite for you specifically what research that is or what percentage. But that is definitely an argument. And it is true and not uncommon for research institutions to partner with other research institutions. The California Institute even partners with the federal government now on some of its research projects. So it's nothing unusual, but it does rebut the argument that all of the money stays in the state of California.
Great. And then one more question about Prop 14, and it goes back to the League of Women Voters Oakland's position versus that of the California League. And it's from Susan asking us to explain why Oakland is disagreeing with the state on Prop 14 and what are the factors that went into that.
I don't think we are not disagreeing. I'm sorry if I presented it in any way that suggested that. As Helen was explaining, this is a state proposition. So as a local league, we can choose to advocate for it, but not to choose to advocate against it. So we are presenting the state's position and the interests of the state league here when we talk about the way the league is advising people to vote.
And Gail, there was an error in the slide on Prop 14 that had the league listed as a no, and it should not have. So that was my error, and I apologize.
And I, as your copy editor, did not catch it. So apologizes to the questioner, and thank you for bringing it up so that we can correct that for future presentations.
Right, so that was it for Prop 14. So moving on to Prop 15. Early question came from Susan, and they're asking about what about the opposition coming from the Black and Hispanic communities and the small business community?
So the opposition has let me just say that the opposition is using some people to make it look as if there is opposition from the small business in the minority community. If you look at the list of the people of all the groups that are in the coalition supporting Prop 15, you'll find that it is a very representative it's very representative of the population, and it is, once again, when I said the opposition is using lies and scare tactics and to cause confusion, that is part of it. So
okay, and one more question that just came in on Prop 15. If a property is exempt, if anyone lives there, regardless of zoning, couldn't a business add an apartment to the property to be exempt?
So that's a very good question, and thanks for it. Yes, you could just add an apartment, but if to gain the exemption for residential property, at least 50% of the property has to be used for residential. And if it's less than that, then it becomes a mixed use, and the residential portion is exempt from reassessment, but the balance of the property that is commercial would be reassessed.
Moving on to the next proposition. We did not get any questions on Proposition 16, so if you have any, you can add them now. But we will move on to Proposition 17. So from Mars, they're asking, is restoral automatic, or will people have to go through some process to get their rights restored? And what about restored rights after their time is served?
Well, I do, they have to apply because they have to register to vote. So actually, it affects your registration. So if you, and that's one of the questions that's asked when you register. So the registration forms and the way that we register to vote will have to reflect the changes that you are in fact eligible to register to vote. And once you're registered, you're registered.
Right. So Mary, just let me say that there would be no additional paperwork or procedures that people would have to go through. It's a normal one just to register to vote.
Right.
And then also on Proposition 17, if this is passed, when will it take effect?
Well, I need to look in the pamphlet for that, but normally these take place within a certain number of days. So I'm kind of embarrassed that I'm not sure. It would certainly be in effect for the next election.
Moving on.
Not for this election, of course, because that's where we're voting on it, but it would be in effect for the next elections.
Okay, so moving on to Prop 18. This is the primary voting for 17-year-olds. We have a question: what 17-year-olds get to vote on ballot propositions in the primary election? Gail, I think you might be muted.
Thank you. Thank you. I was focusing on the question, which is a really good one. I had been considering primarily the candidates because, you know, that's where you see you're carrying over. But it's true that we have not always and often fewer, but there are ballot measures on the primary, in the primary election. And yes, they would be able to vote, and it's not limited as written to voting just for candidates.
Would this be automatic? Would it be the ability to vote for the 17-year-olds? Would it be an automatic registration like the former draft system?
Interesting. Well, what it would allow young voters, it would allow voters of that age of 17 who are going to turn 18 by November to register to vote and receive a ballot. And that's where the reconfiguration at the county and the state would have to happen so that they could process voting materials for that new class of voters.
Okay, so moving on to questions for Prop 19. This is the property tax transfers. Questioner wants to know, is Prop 19 retroactive or on a go-forward basis?
I believe that Prop 19 is not retroactive. I don't know that for certain, but that is my belief.
Okay, so moving on to Prop 20, the rollback of criminal justice reforms. The first question is, does Prop 20 speak to differential sentencing, which is currently a large part of the problem with criminal justice?
So it does not speak directly to that. However, I would argue that by changing certain, to the extent that there is differential in, excuse me, to the extent that there's a differential in sentencing and charging for felonies versus misdemeanors, that this proposition does mitigate the issue by making certain things that might have been felonies, or keeping certain things that might have been felonies and making them, we're actually preserving the current law that would charge them as misdemeanors. So I think it mitigates the issue, but it doesn't directly address the issue.
Our next question skips to Proposition 22, which is the rideshare and delivery drivers proposition. So the first question is, isn't this the type of behavior that led to the formation of the unions in the past? Why can't there be workers who are contractors and workers who are employees? Why does it have to be one or the other?
I'm finding the question so interesting that I'm constantly failing to unmute. Okay, it doesn't have to be one or the other. I think it's partly a question of being in a period when a new classification appears to be emerging, and then questions arise as to how practices, literally on the streets with these delivery and driving services, are going to be handled in the legislature. So you have, with respect to independent contractors and employees, established systems of compensation, like the minimum wage, of protections, like unemployment insurance, health insurance, paid parental leave, this type of thing. And with respect to independent contractors, a different set of governing laws. So the issue here is what's emerging. And it is true that AB 5 is trying to push much of what would be the gig economy into a traditional employee classification. And there has been pushback against the original version of AB 5, and there have been amendments which have established these 50 exemptions, approximately 50 exemptions for a variety of professions, such as doctors and guest artists and hairdressers, as various groups have made their case that being reclassified as employees simply is not viable for them. And the argument of people who oppose this is that so long as it remains in the legislature and a piece of legislation to which everyone must address, then compromises like these can be worked out among our elected representatives openly with hearings based on evidence. Some of the objection to this is that these companies, few in number, but representing the wedge of the gig economy, are doing this through this referendum process and attempting to gain an exemption both from the law and from the legislative process to allow them to work under this somewhat new area that they're trying to carve out as a third space.
And then a question to follow up on that, Gail. Many gig workers work for both Uber and Lyft, and how would this proposition affect them?
My understanding is that it would not affect them, and they would be free as they are now to work for multiple companies. The one way in which the law might affect them or influence them would be that what the companies are proposing is to provide a certain health insurance stipend. And the amount of the stipend is going to vary considerably depending on whether or not you work 30 hours or more or not. So I think, for example, it's 82% of what a certain policy might cost you versus 41% if you work fewer than 30 hours. So some of the stipulations in here might motivate someone to work more exclusively for one company in order to get their hours up to qualify for greater supports in the health insurance realm.
So moving on to Proposition 23, we are asked, why is this perceived as such a necessary issue that we have to vote on it again?
So that's a really good question. And it is because people raised money and put it on the ballot. And we in California feel very strongly that anybody who can get enough signatures should be able to put whatever issue it is on the ballot. And so that is why it's there.
Okay, Proposition 24. Consumer data privacy. What is the league's position on the evidence showing that risk assessment algorithms are racially biased?
That's Prop 25.
Well,
so
this is a good reason why to include your prop numbers in the question so I don't get confused. Prop 25, there was no other questions on Prop 24. So Prop 25, Mary, question to you. I think you're muted, Mary.
Okay, I'm just asking you to repeat the question since.
Okay. What is the league's position on the evidence showing that risk assessment algorithms are racially biased?
Mary, do you want me to answer that one? About
I
the
do.
state law?
I
Okay.
do. Helen was much more involved in the legislation.
So we agree that the law is flawed, and in fact withdrew our support for it at the end when it became clear that those risk assessments were going to be biased. We, however, support Prop 25 because we think that it's really critical to do away with money bail and to allow the legislature to fix the problems with that risk assessment system. Because if Prop 25 fails, if the no side prevails, we will not be able to do away with money bail. The legislature will be prevented from actually passing another law doing away with money bail.
Great. And then one more question for Proposition 25. Asking about wanting clarification on how a high cost of implementation assessment can be made when the system to determine the risk has yet to be developed.
That's a that will be up to the legislative analyst who has made their best estimate based on what it's taken in the past. It won't be the first system we've had to set up in the state. So there is some experience with this. And we know that it will involve a cost to get something up and going and to pay for it ongoing once it's established. Now, how much? That we leave that to the ledge analyst to tell us.
Thank you. So we have one more question that's not specific to any of the propositions, but I think it's in our best interest to talk about it. Mars is asking about the diversity on the panel today. And so I think it's a great opportunity to talk about league membership and representation today. Open to anyone presenting.
So I'm happy to answer that question. And that's a good question. Traditionally, and this is going back decades, the League has not been a particularly diverse organization. And that is something that we are working very hard to remedy. The future of the League really lies in it becoming more representative of the population and of the voters. And we have a lot of programs in place that are working to do that, and they are succeeding. And I don't think you should take today's, the four of us, as representative of where the League is today or where the League is going. This is a very important issue for us. It's a good question. Thank you for asking it.
And our remaining questions are related to the Oakland and Alameda County propositions. So that's a good segue, and I know we're at time. So.
Okay, so who has the first one, Measure QQ?
So that's me, that's Helen. So I'm going to do QQ, and I'll do this is a pretty simple measure. Currently, you must be 18 years or older to vote in an election. QQ would permit people 16 years old or older to vote for school board members in Oakland. It's that simple. There is no fiscal effect at this point, but there would be some extra money every election cycle to administer that, to make sure that 16 and 17-year-olds only got the ballots that included the things on which they were permitted to vote. And there's no estimate whatsoever on the cost of implementation. The yes side says that students are impacted by OUSD policies and should have a say in selecting their directors. And it would also set a lifelong pattern of voting. Once you vote for the first time, we know that you're much more likely to do so in the future, and we want to do that. The League urges a yes vote on this. The arguments against it are just that 16 and 17-year-olds are not trained and have little experience, and that there are other ways to improve voter turnout. But the League is very much for this. We think that we want to engage young people in voting, and this is a way to do it.
Helen?
Yes.
But it doesn't automatically give the right to vote.
No. Thank you, Mary. This does not automatically give them the right to vote because the implementation is not accounted for in this measure. And what it does is it allows the city council to pass an ordinance that would actually implement it. So it's permissive, and we'd have to see what would happen. In Berkeley, where a similar measure passed several years ago, they have not implemented it because they have not been able to figure out how to pay for the implementation. Thank you, Mary. And I'm going to move on to measure RR, another pretty simple measure. The Oakland City Charter has a $1,000 limit on fines for any violations of municipal code. This was last amended in 1968. Measure RR would delete that language. It would delete the limit and would then allow the council to enact new limits as they saw fit. The arguments in favor of this are that we need flexibility to set our fines in order to deter violations. And specifically, they point to dumping. Currently, with a $1,000 fine, people who are caught dumping and fined consider it just a cost of doing business. And so a reset on that limit is overdue. The people against it say that it allows the city council to set unlimited fines, and we have other ways that we should be able to deal with the illegal dumping. The league is supportive of this measure. We believe we should vote, and we need flexibility to set fines at the level that actually will deter the crime. So moving on to some of the more complicated ones.
Okay, this is the Oakland Police Commission. And Oakland voters passed in 2016 overwhelmingly an amendment to the city charter, which established an independent police commission in Oakland. And what the commission does is oversee the practices and policies of the Oakland Police Department. And the commission is empowered to recommend changes to the policies and practices of the police department. Back in 2016, Measure LL also established as an arm of the commission, the Police Review Agency, which looks specifically into reports of police misconduct and investigates them. Now, once that charter language was passed in 2016, the city council worked on what we call the enabling legislation, which is the follow-up legislation to do all the necessary implementation, and disagreements arose as to certain questions of hiring and supervision. So this measure S1 puts those disagreements to rest by establishing the Office of Inspector General. It's an independent office within the commission, so it will have its own Office of Inspector General as the police department has its Inspector General. The commission also is empowered by S1 to independently of city administration hire and supervise the Inspector General and its own attorneys. All of that is in the interest of both apparent and actual independence from city administration, which is, and particularly the city attorney, which is also the attorney for the Oakland Police Department and might have conflicts of interest. This legislation also allows the agency, the Police Review Agency, to hire its own legal staff and to supervise them independently. This Inspector General position is big. It's someone who supervises all the legal claims, lawsuits, settlements, and complaints and investigations, and reports back to the commission members. It's also a position where someone is looking for systematic problems within Oakland Police Department's policies and procedures. In order to help the Inspector General and that office be fully functioning, this legislation gives access to all the necessary police department records and files, all that would be necessary to form an independent investigation, an independent opinion on investigations and on how policies are being carried out. It isn't all about staffing and hiring, though. It's also about the fact that the commission has a certain scope of review. And traditionally, that's been on questions that involve use of force or profiling or First Amendment rights. And the commission is allowed to suggest changes as to police policies and practices that affect these matters. And one reason for clarifying their scope of review is that Oakland continues to be under federal court supervision. At least the Oakland Police Department is under federal supervision for nearly 2 decades now, and that is a significant cost to the city of Oakland. The hope is that in fully empowering and clarifying lines of authority within the commission, we are setting the stage for the ending of that federal review, and that it would be something that the police commission would be fully staffed and empowered to take over on its own and continue. So overall, this is a measure to clarify and amplify the role and authority of the police commission. Those in favor of it say this is necessary for effective monitoring. We want unbiased legal advisors, unbiased in appearance as well as in reality, that it's a pathway away from federal oversight, and that it provides access to all the relevant records. there wasn't really any formal argument submitted against this measure. We, at the Oakland League, since this is an Oakland measure, this is a vote we take at our level, and we are definitely encouraging you to vote yes, based on our position in favor of adequately staffed and empowered commissions that ensure real checks and balances within government. Vote yes.
Okay, I think the next one.
I'm doing Measure Y.
Oh, sorry.
This is a authorization for the Oakland Unified School District to issue bonds up to $735 million in bonds for school classroom repair. Actually, it's we call facilities. So to improve, construct, renovate their facilities. And there is a plan that the district follows. Also, it's important. This was something that we liked. Usually, you have oversight committees that deal with that after the fact tell you how you did. But the oversight committee, through policy that the district has adopted, their oversight committee, which is specified so that it has at least business and parent representation, that they will be looking at projects to be funded before, during, and after they are undertaken, so that the advice will have something, will be reasonable. The bonds, of course, are like big loans, and they have to be repaid. The bonds are not always put up, they aren't all sold at the same time. And the tax that pays for them is not imposed until they are sold. So by the time all the bonds are sold, it's expected that the highest rate that would have to be paid is $60 per $100,000 of assessed valuation. This is not a parcel tax. This is old-fashioned property tax based on the value of the assessed value of your property, which is, of course, different and different from the market value, and varies quite a bit. Right now, if you look at your property tax bill, you'll see that for the school district, because this is hardly the first bond that has been put on the ballot or has been issued by the school district, you'll see that we're currently paying just under $117 per $100,000 of valuation. So that that amount would go up according to whatever, as the bonds are sold for Measure Y. Now, the current bonds all have different maturity dates. The first of which, for the first group of bonds, is 2025. So then, when those bonds are all paid off, then the tax ends. So then the tax would go down. So from year to year, you're not going to see necessarily a steady increase. Well, you won't see a steady increase, but except in those years until the next one is matured. So this is, we support it. The league supports it because we do see the need. Oakland has a lot of older schools, and they also are doing lots of renovations and, of course, trying to adapt to the needs now for distance learning and for distanced learning within buildings when they're able to get there, or when they're able to go back into the buildings. So those people that are opposed, the Taxpayers Association tends to oppose all tax increases. And they erroneously say that bonds are a bad way to pay for capital improvements, but in fact, capital bonds are the standard way to pay for capital improvements. So vote yes, please.
So thank you, Mary. So I have the last two, which are going to be pretty quick. So Measure V is the utility user tax for unincorporated areas of Alameda County. And we have no position on this measure, and I'll just explain it and then explain why. So Alameda County established a 5.5% utility user tax on residents of unincorporated areas in 1992. It was raised to 6.5% for a period of 12 years, expiring June 30, 2021, hence the need for this measure. So Measure V would simply extend this tax until June 30, 2033, with no increase to the current 6.5% tax rate. It is collected in the unincorporated areas of the county, and that includes Ashland, Castro Valley, Cherryland, Fairview, San Lorenzo, and Sunol. Extensions of the tax would provide approximately $12 million annually to fund county services such as the sheriff, the library, planning, and code enforcement. Since its establishment back in 1992, all proceeds of this tax on unincorporated areas have funded services in the unincorporated areas. It would retain current exemptions and exclusions, including exemptions for low-income or lifeline utility users who have medical issues and therefore need their electrical services. The tax is collected from customers by the utility service providers, which then pass the money on to the county. Utility services include gas, electric, telephone, and video. Measure V will not apply to unincorporated cities such as Oakland. Nevertheless, state law requires that all county residents vote on the tax. Opponents say there is no real accountability for how these tax revenues will be spent. But Measure V will preserve revenues that are used to provide vital services, including public safety, libraries, land use planning, and code enforcement. And it will provide those to the unincorporated areas of Alameda County. The loss of the $12 million in revenues will likely lead to cuts in vital county services. Now, Measure V is a county measure, and our league rules specify that the 6 leagues in Alameda County must support a measure in order for the local leagues, such as Oakland, to support it. However, we did not realize until recently that all county voters have to weigh in on Measure V. We assumed that it was just the voters in the unincorporated areas. So therefore, the county leagues did not vote on whether to support it or not. So necessarily, we have no position. And I'll move right on to Measure W, which is the Alameda County half-cent sales and use tax. We're neutral on this one. Measure W would enact a 1/2 cent sales tax to, quote, maintain and improve essential county services to include housing and services for those experiencing homelessness, mental health services, job training, social safety net, and other general fund services. It would provide approximately $150 million annually with annual audits and citizen oversight. Now, again, Measure W is a county measure, and our rules specify that almost all the 6 leagues in Alameda County must support a measure for a local league such as Oakland to support it. The Alameda County leagues recognize the urgent need for, and we support providing services to prevent and alleviate homelessness in Alameda County. However, we have concerns over certain aspects of Measure W, including the regressive nature of the sales tax. So our position on this one is neutral.
And that's the end. So I'm going to stop the showing the screen and then go back to the pictures of us and we can get more questions. Angie?
Right, so we have a few questions starting with measure S1. So Dan is asking, can Oakland afford this measure? Isn't the police commission strong enough now, and won't this raise costs at a time that the budget is being squeezed a lot? Won't this further cripple the police department? And he also adds that his faith in the police commission was undermined by the firing of the police chief last year, and it's not the time to further demoralize and undermine the police department.
Okay. So first thing I want to say is thank you for the question. And let me address the fiscal aspect of it first. There was already funding for the Inspector General position. And so that is not an additional cost. It's already been budgeted. It was the difficulties and the back and forth between the city administrator and the commissioners as to who would do the hiring and whether or not the commission could independently do that. And because the authorizing language for that was not placed in the charter originally in 2016, there was reason for argument. But by putting the language in the charter now that the commission is empowered to hire the Inspector General, then they'll go ahead and do it and the budgeted funds will be expended. There are considerations in the proposal to acknowledge difficult times. For example, I believe there's a provision for 2 attorneys in the commission. And the provision states that if the budget is such in the city of Oakland, the city council is permitted to simply fund 1 of the positions. So there's leeway there with just general guidance to say adequately fund the commission. I think this measure in 2016 was passed by a stunning majority of the voters, and they want a commission to function effectively. And I think, getting off the ground, pieces of it have been rocky, but it's essential to kind of get the framework right, to get the supporting legislation right, to get all of the personnel in place in order to see what this commission can do. And if indeed it is adequately funded and staffed, then it moves us a step closer, hopefully, to where the approximately $2 million a year that Oakland is spending on the federal monitor would no longer need to be spent because we come out from under federal oversight. So there's potential funding there. It does not take funding away from the police department. And in fact, Helen, on the slide of people supporting, don't we have the Oakland Police Officers Union?
Yes, the Police Officers Union is supporting this measure and is actually funding the campaign for the most part.
Yes, and in many senses, the commission is an assistance to the police department. They are currently engaged in rewriting use of force policies, and that is very helpful if we can get to rules, regulations, policies, procedures on things as important as use of force, which have fostered a great deal of distrust and acrimony in the community. If we can get beyond and over them, it's to everyone's benefit. Those of all citizens in Oakland especially, but also members of the police department. And then we'll know the commission's doing its work. So it's not necessarily an oppositional relationship, although it is true the commission can oppose policies proposed by the police department, as the police department can oppose those of the commission, in which case the ultimate decision rests with the council. But very often what you're going to get in the best of worlds, and you're getting now on use of force, is a back and forth that hopefully results in better legislation, better practices and policies, and a safer Oakland.
Okay. Our next question goes to Measure Y. There are 4 previous OUSD bond measures that extend through 2025 to 2040 at a cost of $117 per 100,000 of property value. How can OUSD add more debt on the backs of Oakland homeowners?
Well, excuse me, I'm about to sneeze. I think that the reason is that the district sees the need that the bond funds that are already there have been attached, have been dedicated now, and they need to, and in some cases, need to finish some of those projects with new money. So you would have to ask the board, I guess, why they think, and I guess ask us why we think you should put on more money, and that is the need is there, and it's that, and there's no way around it in terms of how to fund and how to get it done. So and the bond issues, as I indicated, once a series of bonds is finished, the tax for that finishes also. So this is not necessarily going to be a permanent increase, although certainly an increase.
Mary, may I add one thing, which is that in order to qualify for state funds,
Yes.
local districts need to have plans in place and some local funding in order to qualify for matching funds. So it is an ask of the citizens of Oakland, residents of Oakland, but it's also an entree to bringing state funding for the schools into the city.
Several questions came in all at once. So let me get organized here. So let's go to Measure W. Mars is asking, Mars W doesn't seem to give enough detail on how they would go about improving essential services and what the substantive measure of these improvements would be. Would you please delineate which entities would provide the oversight?
I'm going to ask Mary to respond to this because she did a lot of the analysis.
Okay, how they determine it, it really goes through the annual appropriations of the Board of Supervisors. The Board of Supervisors has what they call a Vision 2026, of which, and one of the real elements of that is to end homelessness by 2026, probably a little optimistic, but they want to, that's what they want to aim for. And they recognize that they recognize that the need is out there, the need is growing. And so it really will come down to the budget process of the annual budget process of the Board of Supervisors in terms of what services and what programs will be added, will be improved. It is really up to them how to put the money to the best use. There is oversight which will look at the ballot program, the ballot statement, because the ballot, although it's a general tax, which quite frankly they could use for anything, the Board of Supervisors can, but through their own resolutions and through the ballot statement, they have pretty much they have in fact mandated themselves, put a mandate on themselves to put in place or to fund programs that really help people who are homeless, help people avoid homelessness. I think they felt that they passed Measure A that put in place that was a bond issue, so that there is county money for affordable housing, for renovation of housing. So for capital money, this money will go, but they recognize that in order for people to take advantage of the buildings, they need services, and that's where this comes from. So I think they'll be looking in tandem with what's being done under Measure A also.
All right, so I want to take us back to Measure Y. We have several more questions come in. So we'll start with, if Prop 15 passes, won't that alleviate some of the need for Measure Y's funding? This measure adds $150 plus for any home assessed at $300,000 and goes up from there.
So I'm going to answer that one as the Prop 15 person. Prop 15 provides operating money. So it will provide money to pay our teachers, to buy supplies that teachers need, to do all of that ongoing stuff. What a bond does is it provides the capital money for the big stuff, for the buildings and major equipment, but it's not so there's kind of two separate budgets within any government entity. There's the ongoing budget, and then there's the capital budget, and we're doing two different things this way. Thanks. Good question.
And then again on Measure Y, is Measure Y a measure that requires 50% or more of the vote to pass?
Because it's a bond issue, it requires a school bond issue, and so I'm glad you asked this because I forgot to say it. It requires a 55% vote. Most local government bonds would require a 2/3, but many years ago we passed a constitutional amendment, a state amendment that says for schools and community colleges, 55% vote is required.
Okay, and last question on Y is, doesn't the OUSD measure permit the district to leverage additional funds?
Yes, that is what we meant by saying that if that you have to have something that Gail talked about. You have to have money and plans if you want to get money when it's available from the state, because the state, I've never known them not to require matching funds from the district in order to get funds from the state.
And we just passed a state bond measure to provide that kind of matching money. So this would put Oakland towards the head of the line for that state money.
Okay, and last question, going to measure RR. Does RR make mention of the responsibility of the city to keep its properties adequately maintained? Dumping often happens because the city doesn't do its part.
It does not mention that. It is simply a removal of the limit on the fines. And the city has some programs where they're working hard on the dumping. There are, I just heard about this, there are cameras around the city and nobody knows where they are. The city except a very, very few people, and they are catching people that way. But a $1,000 fine does not mean you're not going to do it again, because that can just be absorbed into the cost of doing business for many of the people who are doing that dumping.
Okay, those are all the questions I have. Last call. Thank you.
Okay, well, thank you again for joining us today. Thank you for sticking it out. It took a little longer than we thought. This is just a reminder that you can find all manner of voter information on lwvo.org and on votersedge.org. We have refreshed our website so that nothing you need is more than a click or two away. And while you're there, please consider joining the League and or making a donation to support our voter education and advocacy efforts. Thank you again, and thank you to all the participants and supporters. Bye-bye.